So while it is considered that state governments are usually responsible for the administration of environmental matters such as land use, water and air quality and pollution, when a proposed project is anticipated to have substantial impacts on certain aspects of the surrounding environment, the Australian Commonwealth Government is likely to become involved in the assessment and approval process. So the Environment Protection and Biodiversity Conservation Act is the key piece of environmental legislation that the Australian government uses in this process. This act provides a regulatory framework for assessing large or complex projects, such as the Oliver's Downs project proposed by Pembroke Resources, in addition to processes overseen by the relevant state government, so in this case, the Queensland government. This act binds all the states and the Commonwealth to protecting important fauna, flora, and natural features, called matters of national environmental significance, for their national and international importance in upholding biodiversity. So while the mine project was already subjected to state-specific approval processes, such as the preparation of an environmental impact statement, Pembroke Resources was further obligated to approval under the EPBC Act before proceeding, as it was identified as generating potential impacts on several matters of national importance, namely threatened and migratory species and water resources. Obviously, the kind of main reason that the mine necessitated approval under the EPBC Act is because the Act is administered by the Commonwealth Government, therefore it's binding to all Australian states and territories. This is definitely not to say that it overrides state law. Instead, it just kind of means that the proponent has to undergo a separate assessment and approval process in addition to those required by their state. However, there is a more implicit reasoning why the project's approval extended beyond that of the Queensland government, and it lies in the discrepancy created by state legislation. So Australia's international obligations under both formal treaties and conventions, such as the Ramsar Wetlands Convention, and informally as a member of the global community, does necessitate consistent policy and quite unified objectives, which obviously is difficult, if not impossible, to coordinate between states. Instead, the adoption of Commonwealth legislation, namely the EPBC Act, it eliminates this disparity and maximizes environmental incomes.